Collateral consequences of conviction due to poor legal representation.
Though there are many issues that influence the consequences of one's involvement in the American justice system, two of the most concerning poverty-related factors are the acquisition of inadequate legal help and the collateral consequences of conviction, both of which have negative effects on the trial process and life after conviction. In order to combat these issues, our society needs to recognize that incarceration rates are rising, provide fair trials for all citizens, educate the American people on how our legal system functions, and increase funding to organizations that provide legal aid to people of low socioeconomic status. One of the most concerning poverty-related issues with respect to collateral consequences of involvement in the justice system is the legal help that one receives or does not receive during the different stages of conviction and trials. The way the justice system in America is presented, it would seem reasonable to assume that if someone is convicted of a crime, they would be able to easily obtain a lawyer to represent them. However, this is not the case for the more impoverished members of American society, who often cannot afford to pay for a lawyer or are only involved in civil cases. They are forced to choose between representing themselves or wasting time and money on a lawyer who could care less about the outcome of their case. In the 1963 case of Gideon v. Wainwright, the Supreme Court ruled that under the Sixth Amendment, states are required to provide people with lawyers in all criminal cases. Gideon had been accused of breaking and entering, but was too poor to afford a lawyer, so he set out to represent himself. When he got to court, he demanded that they provide him with a lawyer, but he was denied and sentenced to 5 years in prison. His case was taken to the Supreme Court, which then unanimously claimed that states should be required to appoint lawyers for those that cannot afford them on their own, creating the Sixth Amendment to the Constitution. The American justice system guarantees that you can have a lawyer in criminal cases, but this does not apply to civil cases. There is a sickening paradox that exists in our legal system today that with so many American lawyers, many of whom are unemployed and in need of work, we somehow manage to still have people who are unable to ever get one to represent them. As a result of this, more and more people are resorting to representing themselves. Most people who choose to defend themselves end up missing the mark when it comes to carrying out a successful trial because they are not properly acquainted with the procedures of a trial. Forcing people to find their own legal assistance leads to hiring lawyers that are affordable and accessible, but often inadequate. The defense attorneys for poor defendants in America are underfunded, which leads to a high percentage of poor people serving time in jail or being executed, all because they could not afford a good lawyer. We live in America, a country that emphasizes the fact that we are all equal under the law. But are we actually equal if we are not all guaranteed the same quality of defense when faced with convictions? Lawyers defending the poor often spend little time with their defendants and rush through a case with someone just to move on to cases that they deem as more important. In 1974, Congress created a nonprofit corporation called the Legal Services Corporation with the goal of providing reduced-cost legal aid to low-income Americans to foster more equality in our justice system. The justice gap is the difference between the legal help that is needed and the resources that are available to help with those needs. As reported in the 2017 Justice Gap Report from the LSC, 86% of the cases in which low-income individuals needed legal help in civil cases were met with inadequate or no help at all, but only 20% of low-income Americans actively sought out legal aid. Of that 20%, only 15% of those who actively chose to pursue help from the LSC actually ended up receiving aid.
All criminal cases are sorted into two major groups, misdemeanors or felonies. A misdemeanor typically includes less serious crimes like minor theft, DUIs, and minor drug charges, and these usually only require up to 1 year of jail time. A felony, on the other hand, consists of more intense crimes such as murder, rape, and grand theft. There are degrees to felonies. A first-degree felony is the most serious, and a third-degree felony is the least serious. Many third-degree felonies include vandalism, burglary, weapons violations, and drug violations. Felonies usually require 1 year of jail time, extensive fines, and are punishable by death. While there is a degree range amongst felonies, it is only used in terms of punishment and jail time. Once convicts are released back into society, they are labeled as a felon for life. This label bears great weight as it affects a convict's ability to become a rehabilitated member of society. Their ability to get work, help from the government, or even respect from society is forever more tainted by their criminal record. The real issue with the damaging consequences of conviction stems from the fact that many convicts may have been innocent but pled guilty for financial reasons. After a person is charged with a felony, the person is brought before a magistrate judge who will set bail. A public defender is not always promised at this stage of the legal process. If a person cannot pay bail, then they are detained pre-trial. If they can post bail, then they are released from jail with the duty of paying heavy fines to bail bond agencies. Next, the preliminary hearing, held within 10 days of the arrest complaint, allows the magistrate judge to determine if the case needs to move to trial by grand jury. The next step is the arraignment, in which the defendant is read the charges against them, and they must plead either guilty or not guilty and proceed to trial or accept a plea deal. The Federal Speedy Trial Act dictates that the defendant has the right to a trial within 70 days of his or her initial appearance in federal district court. A plea agreement can be reached and stop the trial process. Otherwise, a long series of court dates ensues until the defendant is proven either guilty or not guilty. In order to avoid the long and expensive trial process, many people choose to plead guilty to a crime they did not commit. Those accused of committing felonies are faced with the exceptionally difficult decision. They must either choose to sit in a jail cell until their next court date and sacrifice the money they would be making at their job, or shell out large amounts of cash out of pocket to post bail. The right to a speedy trial quickly becomes compromised when a defendant must rely on a public defender. Oftentimes, these public defenders are not the most high-quality lawyers. Seeing as though public defense is a lower-end paying job in the legal field, few people choose to spend their legal talents working for the state in criminal cases. However, due to the limited supply of public defenders working in the court system, a defendant is forced to wait until the counsel can be provided. Although in theory the trial process should move swiftly and be over in a matter of days, this is rarely the case. Rather than become a sitting duck for months waiting to receive a not guilty result through trial, people will often choose to plead guilty, taking a plea deal to avoid extra jail time. With the risk of being found guilty at trial, even if innocent of the crime, a plea deal assures a lesser sentence both in fines and jail time. Therefore, it makes sense that even if a person is innocent, they would choose to plead guilty to receive less jail time and save money. Some 97% of federal felony convictions are the result of plea bargains. The vast majority of people choose not to take their cases to trial because it places too much of a hold on their lives and too much of a financial burden to fully pursue justice in the court of law. After someone pleads guilty to a felony, their life becomes filled with barriers. They face several collateral consequences of conviction. Most employers do not wish to hire convicted felons. Therefore, future job prospects are quite slim. Background checks in the felon box on job applications have become the best way for employers to protect themselves and their customers from danger. Regardless of the degree of the felony, the societal isolation is the same. Jobs that require a government-issued license to work are off the table because the licenses are suspended from felons. Convicts lose their government-assisted housing, and although they are eligible to reapply, the process is very strenuous. Opportunities for rehabilitation into society are scarce, as people are reluctant to give felons a second chance. Once forced out of work, a convict's chances of returning to criminal activity raise significantly. They are strapped for cash, and people often turn back to ways that they know will create easy money. This often means theft, selling drugs, or other criminal activities. These felons find themselves trapped, receiving no help from either their community or the government. Despite the ban the box movement in many states, which prohibits the inspection of an applicant's criminal history until further along in the application process, the discrimination of felons still occurred, but it hid itself in a deeper-rooted issue of our society. The ban the box movement began to draw attention to the racial discrimination between employers, as seen through the application experiment conducted by Marianne Bertrand and Sindhil Mullainathan. In an attempt to make the application racially blind to test racism as a factor in the job application process, hundreds of identical applications were assigned either stereotypical white names or stereotypical black names and sent in to apply for the same positions. It was concluded that the white-sounding names received more callbacks for positions, and that even if an applicant had a black-sounding name and received a callback, they had to fight harder to pass to the next level of the hiring process by proving their skills and credentials. Michelle Alexander goes so far as to suggest that the increase in incarceration rates and its effects of a conviction on a person's future serve as the new Jim Crow laws. She says, quote, "Rates of imprisonment, especially black imprisonment, have soared regardless of whether crime has been rising or falling in a given community or the nation as a whole." End quote. When society recognizes that a specific group of people has been targeted and discriminated against in the legal system and in turn discriminated against in employment, the situation can then be rectified. The first step to ending discrimination amongst felons is ensuring that those charged with a felony are judged with the same intensity regardless of race or social class. In addition to this, the judgment society places on felons should also be proportional to the crime committed. Some felonies are significantly worse than others. Step 2 is to provide those who are charged with a felony with a fair and speedy trial, limiting the need for plea deals. By increasing the number of public defenders available, the amount of time a defendant would be forced to spend in jail would be significantly decreased. If innocent, the defendant might be more likely to pursue a fight in trial rather than take the damage on their record for the sake of saving money. People would also benefit from learning how the legal system functions and what programs are available to them. In addition to this, the programs that are available to aid the poor would be able to perform better with increased funding.